No, he is right here. There's a pending warrant for his arrest, Judge. This is in the state of Florida versus AnthonyScarsellcourthearing1of2. We're here on our motion to surrender and set people bond on his violation of probation. Before I address this matter, I approach judgments.
Okay, and one other thing I just want to mention before you approach it. I need to apologize to you, the advocate, because for security reasons, we should have taken this case earlier, so make sure I pay most attention for next time.
Yes,
So I do apologize for that. Yes, you may approach.
I can't hear you.
I don't want to be recorded.
You're gonna get in front. Bend down.
What?
Okay. Please approach the podium, sir.
Oh, wait.
Good afternoon, sir. Please raise your right hand. Please swear or affirm to tell the truth, and nothing but the truth, so help you God? Thank you, sir. Can you please state your full name,
Anthony Scarsella,
your date of birth,
11/13/1969,
and your age?
83.
Thank you, sir. This is case number 2020 CF 02-8740. Mr. Landy, this is your motion, sir. You may proceed.
Thank you, Judge. So we're here on our motion to surrender Mr. Scarsella and set reasonable bond. Your Honor, a warrant was signed by Judge Crawford saying he's bonded no bond on an alleged violation of probation. Two components. One was alleged social media messages. The other was an alleged incident that took place in Judge Crawford's courtroom that we vehemently contest. We vehemently intend on defending Mr. Scarsella and vindicating him on both of the alleged allegations, especially the ones that are contended by the probation officer. What's our understanding, and it will come out later in court, didn't want to proceed on these violations to begin with. Judge, I would like to take testimony from Mr. Scarsella and his wife, Ms. Christy Scarsella. However, I anticipate that the state is going to argue, and they made me aware a few hours before this hearing, and I do appreciate Mr. Hanson not trying to ambush me with the information, so I do appreciate that. However, I believe his position is misguided, but I believe he's going to argue that Mr. Scarsella needs to be held under the Anti-Murder Act without bond, that we have no discretion to give him a bond. I provided a copy of my authority to Mr. Hanson. I have a copy for the court as well of my approach, Judge.
Yes.
And I do apologize. It looks like something was cut off. I had to run down to the law library, Judge, to get copies of all of this. The first case, and the case that I believe is most on point, is Alcantara versus State. That's found at 39 Southern 3rd 535. That's a 5th DCA case from 2010. That opinion was drafted actually by Judge Carrie Vander from the 18, or originally from the 18th Circuit. And Judge Vander in this case lays out pretty thoroughly and pretty significantly the fact that it's a violation of due process for the state to allege that there's a prior conviction. Now, it was for sentencing purposes, but I believe the same due process concerns apply when you're trying to hold somebody under the Anti-Murder Act without bond for any significant amount of time. Mr. Hanson made me aware that the next violation of probation hearing before Your Honor is May the 2nd. So, Judge, the court's going to hold him under the Anti-Murder Act, and hold him, at the very least, he's going to be held for over a month. So I believe Mr. Scarsella is entitled to due process in the state providing certified copies with fingerprints, with other identifying information, social security numbers, things of this nature, like the court was requiring in Alcantara where they wanted to use that to show that Mr. Manuel Alcantara was a violent felony offender of special concern and posed a danger to the community. Judge Vander found that they did not meet their burden when they can only provide, I want to make sure I get it right, a printout from, I believe it was the clerk's site in this case, maybe I'm messing that up with Smith and Hughes. The other two cases I provided you were Smith versus State, 714 Southern 2nd, 1152. That's a 1998 case from the 2nd DCA. And Kelsey Hughes versus State, that's found at 139 Southern 3rd, 477 2nd DCA. And that's a case from 2014. The only reason I provided you Hughes, Smith is essentially the same as Alcantara, but obviously Alcantara is a different DCA case. It specifically has to deal with what evidence the state has to provide in order for it to be sufficient to show that a defendant is a violent felony offender of special concern, which the document, at least the document that Mr. Hansen provided to me through email earlier today, didn't have fingerprints, didn't have a social security number, didn't have anything other than a name, and Judge, just my own search of Becca showed at least 8 to 10 different Scarsellas in the area, so it would be our contention that Scarsella is a fairly common name. So they would have to provide some sort of, if they wanted this court to find he was a violent felony offender of special concern, that needs to be held without bond under the DNA. And the other thing the court needs to be aware of is this alleged conviction is from 1988. Mr. Scarsella was born in 1969, so if it's him, and I'm not asserting that it is him in any way, and I am certainly challenging the sufficiency of the evidence that the state has, that would put him at 19 years old at the time of that arrest. The allegation before this court, and I'm sure the court has taken a look at it and reviewed it, it's ongoing, and it's one of those discoveries ongoing, and it's one of those interesting situations where there's an alleged violation taking place in court. There's a number of people that are going to be witnesses in this case. I mean, Judge Crawford had to recuse himself because he was a material witness. The state attorney, Bill Rasmus, is going to be a witness, and I had a concerning statement. I probably at this point need to file a motion to disqualify the state attorney's office, because my understanding is that Mr. Hansen had a conversation with Bill Rasmus about this case today. That's concerning to me because I had listed Assistant State Attorney William Rasmus as a witness prior. He's on our witness list that was served upon the state attorney's office, and Mr. Hansen, I'm not imputing him in any way, but what concerns me in representing my client is that he's having a conversation with a material witness in this case that we listed as a witness. So I believe it rises to the level, at least under my research, and I need to do more research, that the 18th Circuit's State Attorney's Office needs to be disqualified at this point. I'd also note, just for the record, that Mr. William Rasmus is Mr. Hansen's boss. So I think that takes it out of the realm of another assistant state attorney who's a material witness in the case. I believe it becomes much more of a conflict when the individual who's making decisions on your employment, your assignments, your salary, promotions, things of that nature, is a material witness in the case. I think you're more likely to bend to their requirements and requests of you than you would in another type of situation. So I do want to address the sufficiency argument first, because I believe the court holds that the evidence that they have is sufficient. I don't believe I'm permitted to go any further. I need to make a record on that, because if it is a situation where I need to file an appropriate appeal, I would have to do that. If the court finds that it's not sufficient for today's purposes, unless they can produce these certified copies or fingerprints, or just some sort of identifying information that's a little bit more than a name and a date of birth. Something. And due process requires that. And that's what Judge Evander says, is that due process requires more than that. Before we're going to hold somebody, curtail their liberty interests, and hold them languishing at the Brevard County Jail, because the dockets, at this point, the only day we can get our day in court, which he's entitled to, is May the 2nd. And if you allow me to take testimony from him, what you're going to hear is that Mr. Scarsella has a traumatic brain injury. The underlying allegations regarding this are a jealous brother-in-law and his wife who are out to get Mr. Scarsella because of his entitlement to property. That's how this whole thing started. It's a family dispute.
Most of the judge court knows, I don't like the judge argument, but I agree with him on one thing, that this court should initially address a very limited issue as to whether this defendant is subject to AMA. And if he is, that's the end of it for today. And all of this other stuff will come up on proper motion. He's arguing the merits of the case now. We're a long ways from Thursday. I object to the scope of his argument on the identity issue.
Response?
Judge, I believe it's important for a totality of the circumstances when we decide whether or not Mr. Scarsella needs to be granted some sort of relief or some sort of bond, that you be aware of the circumstances surrounding the case, and things that may be involved in the case, and the reasons and motivations.
I overrule the objection.
Thank you, Judge. And I will move on from that, but I do think it's important for you to kind of have a clear idea of it, and have a clear idea of who Mr. Scarsella is. Because I think the way he's being portrayed by these complaining witnesses, this affidavit, the allegations contained within the affidavit, they're trying to make this man out to be something that he's not. And, Your Honor, if you hear from him, I mean, the way he addressed the court, I think he was struggling and trying to tell you how old he was, Judge. So we're not talking about somebody who was a danger to the community, who's a violent felony offender of special concern, or somebody that needs to be held at the Brevard County Jail. And another thing we hear about is the medical conditions that this gentleman has, the medication that he has to take. So I don't believe that this is a situation, Your Honor, where this gentleman should be held languishing at the jail pending a hearing. Not with the evidence that they have, and not with the evidence of a piece of paper that has his name on it. So I believe you do have to address that issue. All I'm asking you to do is follow Judge Evander's opinion, which says that a defendant is entitled to someone accused of a crime. The state just can't come into a courtroom and say that you have this offense and not prove it and hold you without bond. Not here, not in this country, not in this courtroom, not in the 18th Circuit, and not in the 5th District Court of Appeal, according to Judge Evander. So all I'm asking you to do is follow the law, require the state to provide you something more to show that he is that he may qualify under the AMA statute. Before doing that, and then if the court grants us the opportunity to have a bond hearing, I'd like to do that because I do think it would be very important for Your Honor to hear from Mr. Scarsella, Mr. Scarsella's wife as well. I think that's the honor. This gentleman's name is what you should be able to.
Okay. Mr. Hanson?
Thank you, Your Honor. What Judge Evander in the Alcantara case says in his written opinion, joined by Judge Griffin and Sawaya, is that when a defendant disputes a prior offense, the sentencing court must either require the state to produce corroborating evidence or not consider the evidence. He goes on to say that some of the corroborating evidence that can be considered includes original court records. We don't have a situation here where the defendant is disputing that he was convicted in 1988 of a qualifying offense of burglary of a dwelling and sentenced by Judge Richardson, as his court records show. This is also not a situation, as in Alcantara, one of the other cases that is involving an out-of-state conviction, where the issue was, okay, are these just records or are these certified records? The reason why this section in the opinion is important that the court can consider court records is because the qualifying offense that the state is relying upon in asking this court to find that he's subject to the Anti-Murder Act is a local offense. We're asking the court to take judicial notice of the following case. 1988-CF-5976-A. State of Florida versus Anthony Scarsella, which was resolved on May 30th, 1988. And the offenses involve burglary of a dwelling, which is the qualifying offense for the Anti-Murder Act, as well as a grand theft, which is not a qualifying offense.
Can you repeat the case number again?
Yes. 1988-CF-5976-A. Anthony Scarsella. Now, Mr. Landy says, well, we want something more than a name and a date of birth. And I did pay close attention when the defendant identified himself here, and has Anthony Scarsella and his date of birth being 11/13/1969. if the court, I'm asking the court to take judicial notice of the clerk's records of the court file in the case number that I just gave you, because in that, not only is there the defendant's name and his date of birth, but there is a Florida driver's license number. I'm going to read it for the record. FL 562, actually, I'm sorry, that's an S. It's a Florida license S 624-006-9410. Also, importantly, in identifying the participant in that 1988 case, the address given for Anthony Michael Scarsella is 1647 San Filippo Drive, Southeast. Okay. Well, in the case that he is on probation for here before us, the case of 2020-CF28740, Anthony M. Scarsella has the exact same Florida driver's license number listed in stack, the exact same date of birth, 11/13/69, and believe it or not, 35 years later, the exact same address of the 1647 San Filippo Drive Southeast. So of the 7 or 8 Anthony Scarsellas that Mr. Landy located in stack, I would be curious to know how many of them lived, other than his client, at that address, because that's where the Mr. Scarsella that was convicted in '88 lived, and it's where this gentleman lives. Now, I became aware of this request for a bond hearing over the weekend because of Judge Crawford's very recent recusal. We had a request for an emergency motion to turn him in a bond hearing, and it requested 15 minutes, which seemed completely inadequate. But I said, well, it's going to be my case, so I will handle it. So in reviewing the matter yesterday, in between hearings, I looked at his old score sheet on this case and saw he had no prior convictions listed, which seemed at odds with what I was seeing in the NCIC printout. And then it made sense because all of the convictions that he does have are more than 10 years old, so they're appropriately not on the score sheet, but they are in his record, which makes their motion for bond erroneous, because they make a very bold, fonted, and all capitalized assertion in their motion to set bond that other than this offense, he has no prior criminal history. Well, he does. Not only does he have the conviction for qualifying offense, burglary with dwelling FP, he has the conviction for grand theft, and he has another burglary conviction from the following year, but that's a burglary of structure, so it's not qualifying. It doesn't make him subject to AMA, but he has at least 3 felony convictions. So again, that
I would object to that as a misrepresentation. Overrule this argument.
So, I recognize that in 1988, the case from 1988, unlike the current cases where there is an icon that you can pull up paperwork to look at the exact documents in the court file, that system did not exist in 1980. Those documents are on microfiche. I was able to get an emergency printout of the microfiche from the judgment and sentence emailed to me earlier this morning after we finished morning court, just so I could provide something to opposing counsel to let them know, hey, I don't want you to be surprised or shocked in court when you find out that we're arguing he's subject to AMA. It's not fair to defense counsel, and I think the defendant should know, what our position is. So I sent that to them, knowing that I was not going to be able to get a certified copy in time for this hearing. So if they're going, 2 things here, I'm asking. If they're going to maintain the position that the 1988 conviction is not him, number 1, I'm going to ask the court to inquire of the defendant whether that's him under oath to see if pursuant to the Alcantara case, he does dispute the prior offense under oath. And if he doesn't, then that's the end of the story. It's obviously him, and we're done. If he does, I'm going to request the court take no action with regard to the bond until I have a few days to obtain a certified copy. We're already working on getting a certified copy of the 1988 conviction. And I would point out, if the court, as the court takes judicial notice of the 1988 file that I gave you, even though the documents are not themselves visible on there, the description of what the documents is. And scrolling down through the events at 05/30/89, meaning May 30th of 1989, there's a whole discussion there on Becca about the sentencing, defendant sentenced, adjudication withheld, defendant placed on reporting probation for 2 years. Well, that's exactly what is in the documents in the uncertified copy of the judgment that I have at my disposal. So there is plenty of corroborating evidence available to this court to suggest that Mr. Scarsella is subject to the AMA Act. In fact, I would suggest that there is a lot more evidence on that issue than what there normally is for first appearance judges handling VOPs. I mean, when does a first appearance judge on a VOP have certified copies of prior convictions establishing AMA? I mean, if it's a local record, a local offense, then they can look at it and they can see it. Otherwise, they have to deal based upon representations or records that are less than certified copies. So I'm asking you to take judicial notice of the official court records of the 1988 case and the identity issues being exactly the same, including Florida driver's license number, race, gender, date of birth, and even a residential address the same 35 years earlier as it is now. But that's him. And he's the man that was convicted of burglary dwelling. Make a finding that it is, in fact, a qualifying offense. He is now on probation for a felony offense after he has been previously subject to a qualifying offense, and therefore he's subject to AMA, he's subject to being held without bond until the VOP hearing, and I am all aboard with trying to get a hearing as quickly as possible. I'm even aboard doing the hearing before a regular scheduled VOP hearing date, so long as the state has the minimum opportunity to get witnesses under subpoena that would be necessary to testify. We normally need 3 to 4 weeks. We're at 5 weeks now from May 2nd. So I would ask the court to make the threshold ruling that he is subject to the AMA Act, and then address the remaining issues from there.
Okay, Mr. Hayden, anything further, sir?
Yes, Judge. We need to make record of all this. So, Judge, first of all, dispute is described as a disagreement, argument, or debate. Well, we certainly dispute sufficiency of the state's evidence, so we do dispute it under our case law. We dispute his conviction. We dispute the sufficiency of this conviction. The other thing I would note, Judge, is in terms of how Becca populates these things. It populates driver's license numbers, it populates dates of birth and addresses and things of that nature. I haven't heard, and they haven't presented any sort of evidence or testimony as to whether these things populate on their own or whether somebody has to input them or things of this nature. And what Mr. Hansen, and he's talking about initial appearance, and we never had to do it out of initial appearance, and Judge, that's an argument of convenience. And defendants' due process rights outweigh an argument of convenience. Same thing you see in terms of when the state tries to ask for no bond at initial appearances, when it's not a capital or life felony, and the judge can't do that because it's unconstitutional. And they always require, or typically I'll see judges require, whether the state had filed their motion for pretrial detention, and the state hasn't done it. So just because it's inconvenient to the state to get certified copies, that doesn't outweigh inconvenience and practicality, doesn't outweigh an individual's right to due process and to not be deprived of their liberty without due process of law. So I don't believe that you can make a finding that he's made under the information that's provided. The other thing I note to you is, first of all, where's the document? I believe that we need to have the document attached as an exhibit so that the record is very clear as to what the document is and what the document actually shows. I can, if I have a moment, I can probably get it printed out or go down to the law library if it has a copy.
No objection.
I'd like to have it marked for identification, please, Judge. I'd like to have it be a part of the record. And the thing I would highlight, I'd like to publish this to the court when I'm done having it marked, is you take a look at it, all this information that Mr. Hansen's talking about, driver's license number, address, fingerprints, social security number, that's all lacking in that document, Judge. You're not going to find a single one of those things I just listed in that document. That's all coming from that the website, which is exactly what Alcantara, Smith, I think it was Smith, it was actually even the clerk's site. I believe that was another case. I do need to put that case on the record, Judge. Just give me 1 second. Because that had to deal with the clerk's site. And the state making the same argument Mr. Hansen is, that it was information from the clerk's site, therefore you have to take it as true. And the appellate court said, you can't do that. So if I can have a second, I can provide the site, because they do need to do that for record purposes.
While he's looking for that, just for clarification, I mean, there was has to be I would argue that the court is entitled to consider public record information for making its decision.
Yeah, so it is Talby versus State. Talby is Taulbed. Found at 277 Southern 3rd, 1133. That's the first DCA case from August 21st, 2019. And in that case,
Do you have a site again?
that was 277 Southern 3rd, 1133. First DCA case from 2019. Again, noted on candor, it has to feel sentencing, but I don't see how that's any different when we're talking about a fundamental right to incarceration. And specifically, I mean, you're talking about incarceration either way. You're either talking about pretrial incarceration or you're talking about incarceration after conviction. And I know in and of themselves those are two distinct things, but they both have to deal with the defendant's due process. And in this case, based on the state having printouts from the South Carolina Clerk Court website, which showed that the original charges were for murder, and stating in an article found online was the appellant's conviction as accessory after the fact of murder, the appellant was sentenced based on the score sheet of the state's recommendation. So, as you can hear, they cited to, I don't know if it was the basis of their argument, but they cited to the South Carolina Clerk Court, the state did, the website in that case. And it's our position, and in Talby, they found that was not sufficient. And I don't believe citing to our clerk's website is sufficient in and of itself either. Other than that, we do want, either way, how the court rules on this, we want a hearing sooner rather than later. My problem is, Judge, every time I want something sooner than later, the state is unable or unwilling to accommodate depositions. And I'm not going to trade off doing depositions for my client to prepare for the hearing just to get a sooner hearing date. And they know that, and that's why I believe sometimes these matters are kicked out. I know they have busy schedules just as we all do, but it seems like I get deposition dates in like August and September. So if I have to, I may have to file an appropriate motion to compel. Again, I think after the information I was provided today, I have an obligation to my client to file a motion to disqualify the 18th Circuit Judicial State Attorney's Office based on the conversations between the material witness and Mr. Hansen, and have every intention on filing that motion, which may, and then how the court rules on that, and whether there has to be further proceedings, et cetera, and so on and so forth. So I just don't want a client sitting at the jail for a significant amount of time. Or like Mr. Conto said in the prior hearing, Judge, which I think should be something, and I used to believe this was something we could all agree on, but I don't know more and more these days, is that we shouldn't want an individual taking a plea offer or feel coerced into taking a plea offer simply because they have to sit at the jail, which oftentimes I feel like it's used as a strategic tool by the state to have somebody sit in jail because they know they're more likely to accept a plea offer if they're sitting in the jail as opposed to sitting at home. And I think Mr. Contos is right in that none of us, and that includes the prosecutors, should want that. To have a client feel coerced into taking a plea deal and not exercise their constitutional rights simply because they don't want to sit in jail.
But I have just one, I don't want to respond unless the court wants me to respond, but I do have a case that addresses the one rebuttal that he said that him standing there and just saying, well, we contest it, that that's enough to raise the issue to require independent proof, because I have a case that on the record provided by the copy, Woods v. State, 4th PCA case, 294 Southern 339, in the year 2020. I'm here for support.
Yes.
Okay. And then the relevant portion
Thank you.
of the opinion, back to my microphone. It's head note 4, which is fairly short, which basically says, if a defendant contests the truth of the prior conviction, then the state is required to corroborate the offense by competent evidence. And then there's a citation, Harvey stating, when a defendant denies under oath that he is the person named in certified copies of judgments of conviction, the state has the burden of proving by other corroborating evidence that those records refer to the defendant before the case. Well, we don't have a certified copy of the judgment yet because we haven't had much time. The court really think this hinges on that. And like I say, I'm requesting that you take no action on the bond until we can have a reasonable opportunity to obtain that. It's not like I've been sitting on my hands to do that. But I do not agree with the defense that it is simply enough for them to march in and say, well, we don't care what's on that, or we don't care what the uncertified judgment and sentence says, even if it has all of these other similar identifying data. We say it's not him. I don't think that's enough to put us to further burden of proof. I think they have, I think the defendant, not the defense attorney, has to do more in order to put us to further burden.
Can I briefly respond to my record? First of all, I don't believe my client has to respond to anything. That's what's called writing and self-determination. So he does not have to answer questions regarding this. I'm not saying how he would answer the question one way or the other, but he doesn't have to be compelled to testify. Again, that's Fifth Amendment. The case he provided, Woods, what I would state to you, the state reported, Your Honor, is that if you take a look at head note 4, the defendant contests the truth of the prior conviction of sentencing, then the state is required to corroborate the offense by competent evidence. Then you would take a look at head note 2 from the 5th PCA, when a defendant disputes a prior offense, the central court must either require the state to produce corroborating evidence or not consider the offense. Well, I believe that's a direct conflict. And I believe the 5th, obviously, we're in the 5th District Court of Appeal. Dispute is different than contest the truth. And I'm disputing, and I read you the concordance definition of dispute. It's to take issue with, to have argumentary debate. And that's what we're doing. We're disputing the sufficiency of the conviction. In Woods, it says you have to contest the truth. So it's our position that Alcantara conflicts with Woods in this regard, and I don't believe it was the intention of Alcantara to state, or the court in Alcantara to state that you have to contest the truth of the prior conviction and not the sufficiency. And I believe the 5th would stick to Alcantara, stick to the dispute, because it would be our position that the 5th got it right, the 4th was wrong, because there's nothing about due process that says you have to contest the truth of an allegation. I mean, Judge, there's entire defenses that are based on the fact that somebody is not guilty, not that they're innocent, not that it's the truth that the offense wasn't, but that's not what our system requires. You don't have to plead innocent to a crime. You have to plead not guilty. And that's why Alcantara gets it right, Woods gets it wrong. Because you don't have to contest the truth of anything when you're a criminal defendant, but you are always allowed to contest the sufficiency of the evidence the state has to try and convict you. So it is or remains our position that the court should just simply apply the 5th DCA, and I don't believe the state would be entitled to a continuance of the hearing to get a certified copy of the conviction, because the court clearly states that they either produce the corroborating evidence or you don't consider the evidence. And I believe it would be appropriate for you, once you take a look at it, I would implore the court to take a look at that document and you know, look at every page of that and really see if you think that that document is sufficient in and of itself to show that the person who was convicted in that document is this child, absent the identifying information that I brought up. I do appreciate the court allowing me to make the argument and make the record that I need to make. So I thank you for that, Judge. And we're asking the court to give Mr. Scarsella a hearing on his motion to surrender. He's doing the right thing. We're trying to get him surrendered to get this matter resolved. If anything, the allegations contained therein are de minimis. I believe they're blown out of proportion by certain individuals. And we have a discovery process to go through why and how things, the decisions were made. And we have every intention of going through the discovery process. And that's all I have to do.
Thank you. Thank you both for your comments. I do have a question because of the cases that the parties are relying on. Most cases where the defendant was getting ready to be sentenced, whether I qualify under the Anti-Murder Act, I think that is a little different from what we have here, because he's not getting ready to be sentenced. I'm not sure that it's the same high standard as opposed to finding someone in a when the person is ready to be sentenced, as opposed to whether the court is making a finding whether the person be held under an Anti-Murder Act and held at no bond. What's your understanding of that, Mr. Blaney, and then as Mr. Hanson afterwards? I think there's a difference.
I don't, just because I believe the same principle applies. The principle is the process. And the concern at sentencing, and trust me, I've tried to research to find something that had to do with pretrial release, and I did not find anything on point that had to do with pretrial release. But the principle being that it has to do with due process. So the concern in the sentencing case is we don't want a sentence or somebody to be incarcerated without proof that the conviction actually took place. In pretrial release context, what the state's asking you to do is follow a statute that allows for no discretion for your honor. And essentially, the same result as in the sentencing case, incarceration and continued incarceration. And what they're saying is due process requires that the state has sufficient evidence to show that there's actually a conviction. And I think that the same principle should apply when you're holding somebody indefinitely under the Anti-Murder Act statute, because there is no discretion. There's no way of challenging it. We can't ask for danger hearings. He sits in jail until the court gives him his hearing. And we all know how long it can often take, despite parties' best efforts to get hearings. So my response to the court is, yes, on its face, I think you can say that this is dealing with the sentencing context, and that's different. But what I'm saying is the principle is the same, because you're talking about due process and whether under the Constitution, the Florida Constitution, you want to incarcerate individuals prior to requiring proof from the state that a conviction actually took place. And I think that's what makes the two things the same, is that we do either, when we dispute it, like Judge Sam said, when it's disputed, the state has to require, the state has to have corroborating evidence of coercion not considered. And because they both have to do with a due process right and a right not to be deprived of their liberty, incarceration, without sufficient evidence, that's why I believe it's
Anything further, Mr. Hanson, answer that specific issue?
Absolutely. There is definitely a different standard. We all know where the issue is establishing prior conviction, which is going to have the impact of enhancing the severity of the offense, or supporting a jury finding, or the elevation of the offense from one class to another. That the standard has to be beyond a reasonable doubt. I understand that's not what those cases are talking about. But in a sentencing context, in an HFO or in a PRR, where you're talking about an enhanced sentencing, where you're moving from one category of punishment to another, that's where these cases seem to be falling. That's never been required to be established beyond a reasonable doubt. It's always been a lower standard with regard to those offenses. Now, we're in a case which is not even, we're talking about a case where even principles like the Crawford decision, we're talking about a violation of probation hearing where the standard of proof is a quantum less. The standard of proof of the ultimate hearing is going to be a greater weight type of evidence. So this particular anti-murder statute was put into place not to enhance the punishment at the end of any sentencing hearing, but in order to protect the community from those people who have a demonstrated record of being violent offenders of special concern or having committed a violation of probation under a certain unique set of facts. This particular defendant has an offense in his background which makes him a violent offender of special concern. He's exactly the kind of person that the Anti-Murder Act was designed to deal with. All of these arguments about convenience and how long it takes to get a hearing for them, I already said I would do, I want, if I had the power to subpoena my witnesses tomorrow, I would want the hearing tomorrow. So I'm not taking very well the suggestion that, oh, the state wants to have him and put him in jail so that they have a better chance to negotiate, a resolution. I don't know what that's based on. It's not true. It's a little hard to take, but yes, hard to take. Yeah, I think there's a different. I think the court's on the right track there. There is a different standard. Certainly, there is plenty of corroborating evidence available to this court in this case. I don't know how you could decide. I'm not going to put it that way. If the court believes that its burden is making a decision whether the greater weight of the evidence shows that Mr. Scarsella is the man who was convicted in 1988 and subject to that sentence, I would suggest to you you have plenty of evidence available and documented through the courts, through the local courts STAC site, which you are allowed to take notice of pursuant to all of the cases in order to conclude that, yeah, they are one and the same persons.
Thank you. Okay. In case number 1988, CF 05 976. This is defense exhibit A. In this exhibit, it's the managed judgment, and it's showing the defendant's name, 2 counts. Count 1, burglary of dwelling, which the attorneys are aware is a qualified offense under the Anti-Murder Act, and count 2, grand theft, which does not qualify under the Anti-Murder Act. Mr. Landy is correct. When you look at the 5-page document listed as the defendant's exhibit A, it does not list the defendant's social security number. I'm sorry. The social security number is redacted out. It has the defendant's race, sex, and date of birth as 11/13/69. it does not show the address, but has the defendant's date of birth, 11/13/1969. When you go into the case at issue, which is 2020 CF 028740, the name the defendant is using in front of this court today is the same name listed in the exhibit, defense exhibit A. The date of birth that the defendant is using in this particular case at issue, 11/13/1969, is the same date of birth listed in defense exhibit A. It does not list, defense exhibit A does not list an address. However, when you look at the case at issue, which is 2020 CF 028740, the address listed for the defendant in that particular case is the same address listed in the 1988 05976A case. At bond hearings, the attorneys are aware that hearsay can be used as evidence. It cannot, it should not be, there's no basis, but it can be used to corroborate other evidence. And in this particular case, in both cases, the same name as the defendant, the same date of birth, and in the ICMS, the system that we use, or the court system, on both cases listed the same address as the defendant. And at this point, this is not a reasonable doubt standard in front of a jury. I think it's the greater weight of the evidence of whether or not there's enough evidence to determine whether or not the defendant should qualify under the Anti-Murder Act based on the burglary of a dwelling conviction in case number 1988-05976A, which is again defense exhibit A. I find that it does. And I'm going to find that in case number 1988-05976, there's enough information to identify this as the defendant before this court, and burglary of a dwelling is a qualifying offense under the Anti-Murder Act. And as such, the court has no further discretion whether or not the defendant should be released on bond. The court must follow the statute under the Anti-Murder Act and hold the defendant in custody under no bond. I'm sorry, but that's my interpretation on this matter, Mr. Landy, and I think, sir, you laid the record if you believe an appeal is appropriate, sir.
Yes, sir.
And Mr. Landy, thank you very much for the advocacy, and Mr. Hanson, sir, thank you very much for the advocacy. And this is going to be, we're going to give set this, where should we set this for a POP hearing?
Judge, I would like you as soon as BOP day, if we're in agreement on that, we want you as soon as BOP day.
Okay, what we can do is we could do 2 days, a VOP day, VOP hearing date, and then Mr. Hanson and Mr. Landy, the third week, on trial week, we could also set that tentatively, if a trial does not go, and then we can do this matter. Would that be sufficient?
Yes, there's,
1 second.
there is some depositions that I have to have done before the hearing. And I would like for the word to state to accommodate that, to believe that would be appropriate in the circumstance, especially with witnesses that were allegedly present, which includes Mr. Rasmussen, under deposition or under subpoena, opposing.
I would ask Ms. Nance, can you please assist the defense in getting witnesses ready for deposition so Mr. Landy can take this as possible? And so if we set a DOP hearing date, we can make sure everything is in order so we can proceed accordingly.
I will certainly assist him with, especially with regard to those witnesses I anticipate calling. He's talking about doing depositions of people I have no intention of calling. I can't tell him who to depose and who not to depose, but, you know, I don't plan on being his investigator in terms of trying to line up witnesses that he may want to call, but we're not going to. I'm available. I want to make sure, I had checked before the hearing that the victim in the underlying case was available for May 2nd, and he was. If I'm looking at the third week of your trial week, I'm looking at like April the 28th on Friday as being a possible date if we would do this.
Mr. Landy, would that be okay?
Just double check. Thumbs up, thumbs down. That date was April 28th, Your Honor?
Yes, it's a Friday, sir. At 9 o'clock.
I do have an adversarial preliminary hearing in front of Judge Crawford. I may be able to reschedule that. I don't want to push this aside, so I will set it to
I understand. That's why I wanted to do our best about it.
Can you make it happen?
I think I.
Okay.
That is good.
Not good, but doable.